What should you do in the first 48 hours after you've been arrested for sexual assault? This is Christina Williams with Just Criminal Law.
And David Mann, legal storytelling specialist. All right, so the first 48 hours after that type of an assault, I think we've talked about before, the very first thing is hire an attorney. Would you agree?
Yes, you need to hire an attorney, and then everything else will be put in place by our office. So first of all, when you are arrested, you're going to have to worry about a bond hearing. And if you have an attorney involved, the attorney can help discuss with the prosecutor any bond conditions, that is, conditions that keep you from leaving the jurisdiction where you've been accused or from having contact with the alleged victim, as well as the bond amount. That is, how much money you will have to post in order to get out of jail. Because when you have an attorney or you have our office, we let the judge know that you've hired us and reinforce the fact that, number one, you don't plan on fleeing the jurisdiction because you've invested in an attorney, and number two, you'll understand all of the conditions that the judge is going to put on you in order to ensure that the alleged victim isn't contacted or threatened or intimidated. So hiring an attorney will get you the least restrictive bond conditions necessary, and because this case is probably going to go on for a long period of time, it's really important that, number one, you get out of jail, and number two, when you get out of jail, you're allowed to go about your business, continue working, and, prepare for trial with your attorney.
So I would say that in most arrests that we've talked about, the section, the part of it where you are talking about bond is probably the second thing. There's also just talking, the police will talk to you first, right? And you would need an attorney even before that conversation?
Most times, yes. Most times the police are going to want to try to talk to you before they arrest you. That way they don't have to remind you of your right to remain silent. And so if a person at all has any inkling that these accusations could be coming down the road, it would be best to get in contact with our office so that you can let law enforcement know you in fact have an attorney, and your attorney has advised you to never talk to the police without them present.
So I'm sure that a lot of people are thinking, there's an investment in hiring an attorney. But that investment is going to most likely pay off in dividends, right? And by hiring your office, that you end up maybe saving money in the long run or jail time. Is that right?
Right, and sometimes those are not mutually exclusive, especially when it comes to a sexual assault charge, because those cases typically involve a significant prison sentence. And so if you don't hire an attorney and invest in a really good attorney, then you may be looking at a very long time in prison where you obviously won't be able to support your family, pay your bills, and that consequence of losing not only your freedom, but also your ability to earn money makes that investment really the only good option.
So if we sort of walk through how this works, there are events like this that end up having that charge where it's very, very clear it was an assault. But there's probably some of them where maybe the evening began with what seemed like consent that then turned a corner. And so the person who might be accused might be in a confusing position of like, do I need a lawyer? What am I doing? Is that fair? Is that realistic? Kind of that type of a scene?
Yes, and when it turns that corner, you may or may not know that you're soon going to be investigated for this. But when you discover that you are and you get an attorney involved, what we look at is two defenses. Number one, it was consensual, and number two, she is lying. That is, it didn't even happen. And so those are the two ways that we are able to defend somebody accused of this really serious offense.
Right. So I think that probably what applies also to this kind of a situation is that the first impulse the person is going to probably have is to try to tell their story and talk to anybody who'll listen. But that is not what they should do, right?
Right. They should turn it over to their attorney, go to their attorney, and let their attorney find out early on, which course are we going to take here? Is it that there was in fact consent, or is it that this is just a fabricated allegation? And we've dealt with both of those situations a number of times. It's really shocking how many times, we end up defending somebody in that exact situation. But if you make statements early on, for example, I had a client who, used some really bad judgment because he and the alleged victim were out drinking. Luckily, there were lots of witnesses that saw them together, saw how she was acting prior to them leaving together. But when it came down to it, she was also engaged, and she knew she was in deep trouble because she didn't go home that night. And she also had quite a bit to drink. So she just says she blacked out and was taken advantage of. Well, he went ahead and made a statement, but he denied even going anywhere with her. And there was plenty of evidence which indicated that they were together because they saw other people once they left together that corroborated, yes, they were in fact together. But because he was afraid of getting in trouble with his wife, he, made the statement that they were never even together, which then, makes him look like he's guilty or he knows he did something wrong when the thing he knows he did wrong was, do this indiscretion while he's married versus the much more serious have sex with a woman while she was unable to consent because she was so intoxicated. So because he wanted to explain himself and get out of hot water with his wife, he ended up, putting himself in a position where we really had to explain away why he denied even being with her.
Okay, so that makes a lot of sense that someone would want to just try to explain themselves to the police and that, maybe they of course shouldn't do that. But even more natural would be to then call your friends or your siblings or somebody else and they shouldn't do that as well, right?
Right, because any statement that you make, if law enforcement later goes and interviews that person, that statement could also be used against you. And, especially when you're sitting in jail and you haven't been able to bond out, you'll have friends and family calling to check on you, and you want to assure them, I didn't do this, and you'll want to talk about the case again. You just have this overwhelming desire to explain yourself, and you just need to keep in mind, you have to keep all of those statements to yourself. The truth will come out. It's going to be a while before you get to take the stand at trial. But keep in mind, any statement that you make along the way can potentially be used against you.
Yes, because all these types of cases could potentially end up going to all the way to trial, right?
Right, and it's a long wait. It's generally, you're looking at 9 to 12 months at least before your case gets to go before a jury where you can finally put this behind you.
So the way to stay calm is to call a lawyer. So you should have this number handy somewhere just in case. And what is that number?
Sure, we'll include a link in the description where you can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.